Okay. Good morning, everyone. Welcome in TV land to the Wednesday, July 15 meeting of the Trustees of Trust Funds. I will call the meeting to order, and as first item of business, ask for motions approving the minutes of two meetings. The first is a revised draft of the May 20th meeting. The revisions are the ones that were discussed at our meeting in June. And the second is our minutes of our June 16th meeting. Do I hear a motion?
So move.
Okay. Any further comments or corrections?
For me.
Hearing none, I'll call the question. All in favor, indicate by saying aye.
Aye.
And the chair votes aye. Okay, next item is the Kohlhaas Memorial Scholarship. In your material, you'll see a draft of the scholarship trust agreement. Jen is here and can supplement this, but she was successful in working out the terms of this scholarship arrangement. Mr. Kohlhaas, he has signed off on this draft. What we'd like to hear from you today is any comments or questions you have about it, and if you don't, then to approve the form of the agreement, and then it will go to the school board at its meeting in the first half of August, and then come back here for signatures of, presumably by the time we get back here, the draft will have, or the final version will have the signatures of the superintendent as well as Mr. Kohlhaas.
I would move that we accept the draft agreement as presented.
Okay, do I hear a second to that?
Second.
Any further discussion or questions?
Good job.
Hearing none?
Yes.
We'll call the question. All in favor?
Aye.
Aye.
And the chair votes aye. Yeah, and this, Jen has done a great job of incorporating a lot of the terms that we've been adding to different agreements. So this is close to being what will be the template for future scholarships that will make the process quicker. So, okay.
We haven't gotten a check yet.
No, that one, it's not due until it's signed.
Okay.
Okay, next item on the agenda is request for distribution from the Public Arts Trust, and it's in conjunction with the Nebi sculpture. So you recall from, this was actually teed up for our June meeting,
right,
but we had not, as of that time, received a copy of the certification of the clerk as to the city council vote to authorize the expenditures. The council had previously authorized the city manager to enter into the agreement with the Nebi artist, but at that time had not also authorized the use of the funds that Park has been raising to pay for that, and they have now done that, and that certification is, I think, the second item in the packet. And so this is ripe at this point for approval and disbursement. So I would entertain a motion.
I move that we disperse the funds as requested and certified.
Okay, do I hear a second?
I have a question first.
Sure.
So, thank you, Peter. Just a point of clarification. Are we approving phases 1, so the 30,000, 20,000, and the 7,500, or is it just the 30,000?
Well, we're only approving 30,000 today.
So phase 2.
That's right.
Okay.
Yeah, phase 1 was
It's already been
paid.
dispersed. Yeah.
What's that?
Phase 1's already been,
Yeah, and that was out of city appropriations. It was not under the monies that was raised by the park committee. So, and this is actually, the city council vote is meant to allow us to disperse at the request of the city manager under the contract without it having to go back to the city council for each individual disbursement, and that's why it's set up that way.
Gotcha. Thank you.
Speaking of, just want to
Morning, Chris.
acknowledge who just came in the room. Maybe you'd like
Yeah.
to.
We're about ready to vote on monies for Nebby for you.
Okay, good, good.
All right, any further questions on that motion?
Oh.
No.
All right, I will call the question. All in favor indicate by saying aye,
Aye.
Aye.
and the chair votes aye. All right, next item on the agenda is another request from, for distributions out of the Public Art Trust. This one is for the repair of the codfish sculpture, the cod in the Mortal Sea that's out of Blanco Park. So this is the request to disperse $3,000 from the city council capital improvement plan appropriations that have occurred over the last couple of years.
Would be approved as requested and certified.
Okay. Do I hear a second?
Second.
Any further discussion on that? Hearing none, we'll call the question. All in favor indicate by saying aye,
Aye.
and the chair votes aye.
Could I please note that I do not have a check for that right now because those funds are in a different account than the checking account. Because they're public monies, we have them in a separate account.
Yep.
So Tom, I'm gonna need you to go with me to get those funds out, to have them cut a check.
Okay, when do you want to do that?
I'm off tomorrow and Friday, so either this afternoon or Monday.
All right, well, we'll just do it this afternoon.
Okay.
Okay.
Yep, thank you.
All right. So next item, number 5 on the agenda is a discussion on the disbursement procedures. So I asked to put that on there in 2 regards. The first is that Jen and I have been working on trying to develop some template resolutions to try to address the sometimes very inconsistent votes that are taken by the city council. So for instance, a vote to approve a contract, but not to vote to approve the disbursements by the trustees at the same time. So we've got a first draft circulating and Jen's gonna finalize that. And then we'll bring it back here for approval. And so hopefully anybody dealing with disbursements, not just for the public art, but for the other disbursements requested, will understand the procedure. We'll have a resolution that can be placed in front of the city council and take care of that. The second point is that, and this I guess for your benefit, Chris, is maybe 3 years or so ago, maybe even longer, the trustees adopted a policy that requires that the city manager or somebody coming in with a request for a disbursement that's made pursuant to a vote of the city council, provide us with a certified copy of that vote. And the reason we adopted that is because oftentimes these requests were coming in shortly after a city council vote, but there are no minutes available. And we needed something that documented the vote to do so. And we follow that policy. That, in fact, has been incorporated into what Jen and I are working on as templates. But I'm of the understanding that the currently the clerk's office is producing the minutes of the city council meeting much quicker than has been the case in the past. And so even on the items that we just voted on, you'll see a page of the minutes of the city council meeting with the vote. And so we didn't have the benefit of those. So my question to you is if we have the minutes of the meeting that actually have the text of the vote in it, will that satisfy our request for documentation?
As long as people realize if we don't have those minutes, it won't be voted on.
Well, this is not changing our basic rule, but
Okay.
what it's saying is, you know, if, we need documentary proof
Right.
of a vote being taken, so we don't have to go watch the last council meeting or
Well,
something.
but I do think what we've been doing has worked.
Well, it has.
So if something's worked, I don't know why we change it, so.
Well, the only difference is, and Judy can speak to this, is that, you know, she can go down and get a copy of the minutes like this. If she asks for a certification, it takes somebody in the office to go and prepare. I guess I'm looking at as sort of in the alternative. You either produce the minutes of the meeting showing the vote, or you produce a certification because the minutes aren't available. We still get a documented proof of the vote.
That's fine. But I'm gonna be a stickler if we don't have that, we don't vote.
We're not gonna change that. Chris?
Fine.
Okay. All right, so then I would entertain a motion from one of you to modify our current policy of requiring a certified copy of by the clerk of the council vote to requiring either a certified copy from the clerk's office of the vote or copies of the actual minutes of the meeting reflecting the vote that's in question.
So moved what you just said.
Okay. Second, okay. Any further discussion on that?
Yeah, actually, could there be an instance where between, and I'm sure this is the engineer in me, where we get the meeting minutes as we have here and something that's certified, anything that changes along the way. So let's say that we vote on the verbiage from the meeting, but somehow between there and the certification, it's changed, but we voted in the beginning of the process. Is there a way to close that loop if that
That
happens?
won't happen because
Right.
the minutes are the minutes.
Okay.
Yeah.
Right,
Okay.
so the minutes are actually voted on and approved by the council, just like we do here. So
So
they'll
it's
be
just the
approved.
process between the meeting minutes and when it gets certified, nothing changes in between?
Correct, so in
Got it.
other words,
Okay.
But just to realize, Chris.
Yeah.
That the minutes aren't approved till the following council
I
meeting.
was just going to say that, so what will happen is if.
This is
if
helpful. Thank
we
you.
have-
Yeah.
We have a trustee meeting prior to them certifying or voting on
Yeah.
approving the meeting minutes, then we won't, we won't have anything because at that point, so the timing has to be that anything that anybody wants the trustees to go ahead and vote on it. But we technically, most of the time we do that now anyways. It's only been once or twice that it's got kind of backwards, and that was a while ago, where everything needs to be, go through the council first and have everything approved, and then go forward. If the meeting minutes haven't been approved, but we're meeting before that meeting, then we would get the tax certification from them saying they did vote on it, and then we
Okay.
can go.
Thank you.
We're covered.
It's helpful, thanks.
Yeah.
Thank you.
Yeah.
All set, Mr. Chair. Yeah, thanks.
Okay. So then I'll call the question. All in favor indicate by saying aye.
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 And the chair votes aye. All right. Next item on the agenda is a request for distribution relating to the indoor pool. Notwithstanding the language that's in the request, it is not the Portsmouth Indoor Pool Trust. It's now the,
Right, well, Karen's memo is the correct.
but people are so used to calling it the SIP.
Right.
But, so, I don't know if you've had one of these, I don't think you have, Chris, that since you've been a trustee, but there is a fund that was established in 2023 or 4 with a private donation from a nonprofit that had existed prior to that for purposes of supporting the city's effort to maintain the indoor swimming pool. And at that time, that nonprofit wanted to dissolve, and so it reached an agreement with the city to turn over a substantial sum of money that was held by us in trust, and with the agreement that the city had to make certain commitments to maintaining the pool, having it adequate personnel, et cetera, but also provided that any that any expenditures made by the city, capital expenditures made by the city to support the ongoing maintenance and improvements would be shared on a 65-35 basis between the city and this trust. And so we've had these requests before, and it doesn't require a separate vote of the city council because it's specifically laid out in the terms of the trust. And so what you have before you is a proposal that that the Recreation Department has made to make repairs to the indoor pool that are gonna cost $35,247. And the trust would share 35% of that, which turns out to be the number shown, the 12,336.45. So
Move the request be authorized and forwarded to the city as payment of the improvements to the swimming pool as outlined in the agreement for the remainder of the months held.
is there a second to that? All right, so there is one little thing in here that I'd like to suggest as an amendment to your motion. Maybe you can accept it as a friendly amendment. So the terms of the trust say that the trust will expend 35% of the contracted or expended cost of the capital improvement plan project. Of the monies that make up the 12,000 plus is an expected cost of $1,500 for out-of-pocket expenses associated with the putting in a new ceiling in the office. That money has neither been subject to contract or it's just an estimate made by the recreation director. So I think, to be consistent with the terms of the trust, I think it ought to be handled one of two ways. One, it would be, I think it's part of the project, so it should be included if the funds are expended. So I think we either agree, we proceed to disperse the entire 12,336 with the caveat that if the that we require proof of the $1,500 expenditure.
I'll add that to my motion.
Okay, and then if for some reason or other that's not received, that 35% of that $1,500 would have to be restored to the trust.
Do you want to provide a little bit more wiggle room, so not to exceed maybe a number more than, a little bit more than 1,500, so if it comes back and,
Up to $1,500?
or not to exceed 2,000 if they, for some reason?
Well, except that then you gotta go back and recalculate it because it's only,
Correct, and I've got a check
Yeah.
here, so.
Okay. So that number was a
they get the
firm number?
1,500.
Well, no, see, the problem is it's not, it's the recreation director's estimate of the cost. In other words, this was sort of you notice he had a lot of,
Yeah.
cost of different equipment and pumps and things like that. He had done the research. And then it occurred that since they were tearing up everything in that area of the pool, that it would be appropriate to fix the little office in there to put some
Sure.
sound deadening in there. So I would suggest we proceed with the motion as amended if you'll accept the amendment.
Yes.
And if Todd should find that the cost is more than that, I think he could come back and ask for a supplemental, like, if it turned out to
and then
be.
we'd have to then recalculate the 35%.
Sure.
Yeah.
Yeah.
And
This way here, it's, if he gets it done for that, it's a done deal.
Okay.
okay, so you accepted?
I do.
Okay. Any further questions or discussion? I will call the question. All in favor indicate by saying aye.
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 And the chair votes aye. Okay, well, moving quickly here.
Mr. Chair, just for your information, Attorney Griffin is in the lobby.
Okay. All right,
No, I told
the
him.
next item is on the agenda is the Walter Wakefield request. We had originally asked Attorney Griffin if he could be here for 8 o'clock. I'm willing to break now, let him come in
Yeah.
and make his presentation, and then we'll get back to the rest of the items.
Are you gonna go? Okay.
Chris, you gonna run again?
What?
Never.
Yeah.
No.
How many years you do it?
How many? 14.
14.
It's a long time.
Yeah, it is a long time.
Oh, that's wonderful. Peter, good to see you.
Nice to see you, Mr. Griffin.
Kyle Griffin.
Hi, Chris Clement.
Chris Clement, nice to meet you.
Meet you as well.
Jennifer.
If you grab a seat over there.
Sure. You want me to sit right here?
Yeah, that's great. Either side, whatever works for you.
Okay, this is easy enough. I'm facing everybody. All right, so I'll start. So as a way of background, I represented Mr. Wakefield in the condemnation action that the city of Portsmouth brought for 1070 Lafayette Road. And I also represented him in the resulting eviction proceedings in the Portsmouth District Court, as well as Rockingham Superior Court litigation that was brought by the landlord. So that's kind of my background with Mr. Wakefield. Jack McGee was his long-serving attorney, but Jack had retired in 2024, so I had taken that over. I can let everybody know that prior to Mr. Wakefield's passing, we had sat down on numerous occasions and discussed revisions to his will and trust, which were never signed prior to his passing. So the documents that we provided to you for his last will and testament and trust are the legal documents that cover his estate and his trust assets. So
Did they coincide with his last request?
no, not at all. But it is what it is, So also I can let you know that prior to Walter's passing, he had informed me, he was a complicated guy. He had no family here. I mean, you guys know, I don't have to explain that to you, if you've kind of.
I sold many old Portsmouth books to him.
Did you see, so his demeanor and behavior, and everything was very secretive. Even with me as his attorney, but he said, Kyle, I will leave you a list of where everything is. I'll tell you, this is where it's gonna be when I die. And as soon as we got, access to keys to some of the vehicles on 1070 Lafayette Road, there was a 7-page note that, basically detailed, bank account information, his lockbox at Citizens Bank, where the titles were to certain vehicles. So we all know that there was the 23 unregistered vehicles that were on the property at 1070 Lafayette Road. Those were taken away, and they were all junked as far as I know. That was the landlord who had the responsibility to do that.
And what happened to the books in those vehicles?
The books and the vehicles were not worth anything. A few of the vehicles completely fell apart. I can let you know from my understanding that the valuable books were contained in a specific area within 1070 Lafayette Road that has now been cleaned out by the landlord. I'm assuming, I'm not privy to this information specifically, but I'm pretty sure it was from a directive from the city to get that cleaned out as well as the vehicles off the property. That was the last understanding that I had. So any of the property that was in 1070 Lafayette Road that would have been valuable, and I'm sure that there were some valuable books, were legally abandoned to the landlord, and the landlord then further had a responsibility to bring the property out of condemnation. And that was one of the bigger issues that we had. We had the vehicle issue, which really wasn't defensible, but the property itself, we had a civil engineer, go in there, and besides the overwhelming amount of books in there and how they were stacked, the building itself wasn't necessarily dangerous. It was just the way that Mr. Wakefield had that set up for probably the past 30 years. I don't think it changed much. So unfortunately, whatever was in value in there would have gone to the landlord, and that's just basically how that works. But from what my understanding is, and I'll go over this when we go over the estate, is that the landlord is not going to file a claim against the estate for remediation costs. They could at some point down the road, but we're looking at a six-figure number, based upon what was tossed around in the Superior Court litigation. I don't know what that number ended up being, but their quotes were like $150,000 to do what the city was requiring them to do, to bring the property up into compliance. So Walter had told me, and I've got a voicemail, and this John Lemieux, who's been appointed the administrator of the estate, is who Walter, he wanted me to do it. I said no. I said because I'll be the attorney for the estate. I don't want to. John Lemieux is an auctioneer. He does estate stuff. This is what he does, clean out stuff. That's how him and Walter got to know each other over the years. They've known each other for 30 years. They were very close. John Lemieux was actually very involved from the beginning of the condemnation action, offered Walter multiple occasions to take the vehicles off the property for no charge, and Walter was not agreeing to that. So he's known about this. He's known where Walter's things are. He's been able to, so I didn't want to be the one that had to go into 47 McKinley Road and start I've been in there. I hope I don't have to go in there again, especially the basement, but to start, looking around. I can let you know that the property itself, the main entrance is through the garage. There's one narrow pathway to get into the house, which is stacked full of stuff that is all moldy, and we don't know what's in these boxes. There's probably hundreds of boxes in there. You get into the kitchen. Incredibly, there's like a new refrigerator in there. I have no idea how that would have gotten in there, but it's a small kitchen area. All his clothing is in the kitchen area, stacked up on the kitchen table. And then you wind your way through the house and the book stack. So it's not as cluttered as the bookstore was, but it's pretty cluttered. He's got a living room area. Upstairs area is 2 bedrooms. One, I believe was his wife's. That's pretty actually clean, and then his is not. He hasn't had running water there since 2013. He was keeping the electricity on as far as I know, but I think John's still been paying the electricity there.
They haven't known any water since when, Kyle?
2013. He tore up all the pipes, and no heat since then. So most of the bathrooms, I don't know if the bookstore had a bathroom or where he used the bathroom, but it's not as bad as I thought it was going to be compared to when I saw the bookstore, but it also isn't very habitable. So Walter has a trust that leaves everything to the City of Portsmouth trustees for the use of Prescott Park. However, he didn't really put anything into his trust. So if anyone knows anything about trust in the state law, is that you can have a trust all day long, but if you don't tie your assets to the trust, then they become probate assets. So 47 McKinley Road was deeded back to Walter last year, so that's a probate asset. The vehicles in his driveway, which are all non-operable, are probate assets, and they're all contained in the inventory. He did purchase a new vehicle recently that John was able to sell back to the dealership for a $4,000 profit. So what we're looking at right now in the estate administration is we have the 3 quotes that you should have in your materials. John's quote is far lower than anybody else's. The other issue we have too is it's not like we can go and give someone a check for $100,000 and say clean this out. I think we've got $13,000 in the bank account right now for what's been liquidated. So we need to get the house cleaned out. John would have a claim against the estate for the $80,000. And then we need to get the property listed. So we've had a CMA, which should have been, sent out. Has the property range over $500,000? That would be a miracle, I think. But it is Elwyn Park, and then there's a half-acre lot, and so that's where the bulk of the money is going to come from. Potential claims against the estate would be MMCT Realty, the landlord, for remediation costs. Although I don't believe that they are going to do that. I can confirm. There's probably going to be a Medicare lien for his end-of-life treatment, I assume, because he was med-flighted out to Boston. So I think that Medicare will come in with a lien. And we've been dealing with a ton of crazy people and family members from all over the country since this all happened, calling our office. And I think there was one article that had my name in it, but I tried to stay out of most of those articles in the newspaper because I didn't necessarily want to be tied to some of this stuff. But there could also be a claim at some point from a family member, but they're obviously disinherited in both the will and the trust, so I'm not concerned about that. So Jack McGee has declined to be the trustee. I sent the declination over yesterday, which I signed with him yesterday. We probably need to appoint a new trustee, though I don't believe that there's going to be significant trust administration if we're running everything through the probate case, which means Walter's personal property technically is a trust asset. The effects in the home, and you guys would be welcome to set up an appointment if you wanted to walk through and see what we're dealing with. We're claiming it's zero right now, but upon stuff coming out and being more thoroughly gone through, it's not going to be, every book's not going to be looked at, and I mean, there's thousands of books in there, but if there's something that catches John's eye or somebody else, that will be separately inventoried and added to the existing inventory that we have. Walter had 5 storage units. John's consolidated them down to 2. They're at U-Haul in Portsmouth, and then the extra space, which is behind that little strip mall. I'll have an inventory on that, but it was mostly junk through those as well. So I do believe that the valuable books were in 1070 Lafayette Road, and from what I've heard, they hired a company out of Rhode Island who specializes in going through these types of books and figuring out what's worth what, and they spent 2 or 3 weeks doing that. So
And you have 2 motorcycles?
he did. He's got 2 motorcycles. We're selling. They're junk. They were sold yesterday for $1,000 a piece.
I mean, he rode them right up to the end.
He hadn't ridden these in 3 or 4 years, I believe. Yeah. They're in the years and dates are in the inventory. I think one was 73 and one was 78. And then he's got the vans outside there, and so what I'm envisioning is that the probate gets administrated, the expenses come off, and then there's a check that goes to the trust that goes to the trustees. So the trustee's role for Walter's trust may be just opening up a bank account. There are a couple citizens' bank accounts that we couldn't access because they're in the name of the trust, but I looked through Walter's banking records and there's like maybe $200 or something, but still, if you open up a trust account with Citizens, they'll merge the other accounts to it. And then basically cutting a check to the city of Portsmouth for the uses in the trust. If the city of Portsmouth wants to take the position that you want to be more actively involved in liquidation of these things, we can consider that on the trust end, but I don't think anyone else does. I mean, I'm very satisfied with the work that this John Lemieux has done, and he can come in here and meet with you guys at some point. He had a prior commitment, a long-standing commitment, because I had asked him about this date as soon as I had learned about it, so I intended on him being here. But everything will go through, so once the house is sold, we just have to basically wait the 6-month period of time for probate to run its course, pay all the claims and creditors if they come in, and then do a final accounting for the probate court. And then once that's approved, we just cut a check to the trust, and whoever the trustee is at the time, cuts a check to the city of Portsmouth. That's the plan, at least.
Who's gonna sell the house?
We have Tom Gorski from Dustin Letty, and I've worked with Tom on other cases before, and I find him very confident. It's a challenging job. It's not like,
Yeah, no, I understand that.
yeah, he's fantastic. I've had him on a couple other cases, and I know him personally, and they chose him independent of my knowledge of even knowing him, because he had sold a couple of houses for John and his wife, but he's certainly comfortable taking on that job, and I'll obviously look at the commitment. Like, we don't have him signed up yet, as far as a listing agreement.
You gotta clean it out first.
Yeah, we got to clean it out first, and that John said once he hires his crew, he gets the dumpsters lined up. I think there's only 1 or 2 cars left. I haven't been by there in a little bit. Then it will take him about approximately a week, you know, for them to go through and do all that.
How does he get paid?
He gets paid at the end of the administration of the estate, so he technically has a claim for his work.
Is he licensed?
Yes. Yep.
Auctioneer?
Licensed auctioneer and licensed to do, he has his own LLC to do cleanouts too.
That's the storage wars.
Storage wars, yes, correct. Yep.
There's two different addresses for him, one on Union Street, one on Islington Street.
He just bought the property on Islington Street at the end of June, so I've already filed something with the court to update the address, but he's in Florida I guess he's partially retired, but he's in Florida most of the year, and he's here from like May through October 1st. But he comes back and forth to do stuff up here as well. So they just bought 962 Islington Street, number 1. It's got that nice farmer's porch out front, you know, kind of across from where the Choppy Sticks restaurant is towards the end. Yeah. So that's kind of the game plan. This is really, I just wanted to inform the trustees of kind of where we were at, you know, in this, you know, process. It's moving much faster than I anticipated it to, and that's because John is, you know, taking a lot of time to do all this and wrap all this up. These types of cases that are complicated with consolidating personal property and removal of personal property can sometimes take, you know, well over a year to coordinate everything, and that's not going to be the case here.
Questions? Just a couple things as I look through the materials. And I wasn't clear from the comment you made this morning, is it your intent to file a motion to have John appointed as trustee of the trust, or leave that?
I'm going to leave that alone. That was my initial intent, and the more I looked at it and reviewed the trust and what he told me, I thought there was going to be two parallel processes that needed to happen. There was going to be estate administration and more of an active role in trust administration. I don't believe now that I've looked at everything and what he's been able to do for the estate, I don't believe that we really need a trustee at this point because, you know, like I said, the trustee is just going to be accepting the funds from the estate and just distributing them, you know, per the terms of the trust. So that was my initial intent. That's not anymore. And
So if you were to go through the process of liquidating everything, selling the house, et cetera, when it came time to disperse the pour over into the trust, would you need a trustee appointed by that point?
yes,
Right. So the decision on who the trustee would be is deferred until it's time to.
it's basically deferred. I mean, the trust document, essentially, you're the only beneficiary to the trust.
Right.
So the trust document pretty much gives you discretion. If I didn't agree as an interested party, then I could file a petition for equity in court, but we don't want to do that. So we can defer that until he was appointed on June 23rd. So at the minimum, we got to keep this thing open until December 23rd. So it's not like that there's a lot of time or we have to make a hasty decision. And if any point in time I feel like a trustee needs to be formally appointed to do something, you know, legally on behalf of the trust, then we can reconvene on that issue and figure it out. Right now, we don't need anybody to do anything.
Okay. I can't imagine that any of us have any interest in walking through the house.
Okay, I just wanted to offer that because that is.
I appreciate that. Was Walter as a tenant individually, or, I mean, he didn't have a LLC or something?
No lease. Terms where he paid the property taxes and he could operate that business as long as he wanted to. He had a great relationship with the landlord, or the landlord just didn't want to deal with it until after he passed. I don't know what the situation was, but yeah, there was no lease involved. I mean, that's because of how loosey-goosey it was. I was able to drag the eviction process out about 9 months, you know, before we were at the Supreme Court level when the Superior Court, we were going to lose at the Superior Court level regardless, so I advised Walter to not even bother spending the money at the Supreme Court level because the end was going to be the same. But no, he didn't have any LLCs. It was just Walter Wakefield Antiquarian, or however you pronounce it, bookstore. That was it.
Yeah. You don't anticipate any taxes?
That, I don't. That's the one item of his finances I don't have, is his taxes. I generally, I haven't figured out that issue yet. I don't sometimes always tell my clients to file taxes in the States if it's Social Security income. I don't believe he had a lot of Social Security income. But that is certainly something that's still on my radar that's kind of unresolved.
Okay. But I'm guessing though, with the loss of his entire inventory, he probably has a loss that would far exceed whatever his tax liability was. But you might need to file the tax.
We might need to file the taxes anyway, yeah. I would,
To your knowledge, when's the last tax return that was filed?
I don't know. I find it interesting that I found, he gave me everything else that I mean, there's 2 big boxes. I haven't found anything from the IRS in either of them. Not to say that, taxes weren't paid, I don't know. But the tax return likely will still be filed to some degree. But I don't think he's gonna owe anything. I mean,
Oh, but yeah, well, how are you gonna put it together?
I'm not going to. John is. He's gonna try to.
I guess that's my questions.
To your knowledge, Kyle, the fines are such that are owed by the landlord, and to your best of your knowledge, he's not gonna come back after the estate.
I believe if the city eventually levies fines, that they will come after the estate, but I don't believe he's gonna come after the estate for the remediation cost of what they had to do to clean up the property. So those are 2 different angles here. I don't know. I haven't been involved in the case since Walter's passing, so I don't know where things are at. But city legal would probably know, where things are at in that case.
Negotiated.
It was significant though, wasn't it?
Oh yeah, it was probably over $1 million by the end of it. I mean, depending upon the judge's interpretation of, is it 23 fines a day or 1 fine for non-compliance a day, and that makes a significant difference in the amount.
So if it stood the way it is, it could be more than what value of what may be left.
Yeah, it's all off. Yeah.
Significantly.
And so the landlord would have the 6-month window to notify you of any
Yes.
claim, so.
Yeah.
So it sounds like you anticipate, in the absence of some litigation on that issue, that you'll proceed with selling the house. I assume the court will grant your motion.
Yeah.
And then you'll liquidate everything within the next 6 months, wait to see if there are any claims, and if there aren't any, you'll wrap up the estate at that point?
Yes. Yeah, that's the intent. I get paid, John gets paid, creditor claims get paid, and then the rest of the money goes to the city. So if we don't get a claim from the landlord, I'm anticipating it's gonna be a good amount of money to the trustees. It's gonna be 6 figures at least. But if there's a claim made by the landlord, it has to be an actual claim. It has to be, we paid the city of Portsmouth X amount of money. So I guess the city of Portsmouth's getting their money no matter what, but
Different numbers, though.
just, yeah, different number and different allocation, I guess, but that's, so I've tried to stay, I have kind of, I've talked to the landlord's attorney, a bunch of different times after Walter's passing, but I just, I haven't asked him for an update on that.
Who represents the landlord?
DTC lawyers out of Exeter in Portsmouth,
Which lawyer there?
Chris Hilson.
Okay. Well, do you have any questions?
No,
about us?
no, not at all. I mean, if anything, I can keep you updated. The next thing that will be significant for the city is when the house sells. If there's a big creditor claim that comes in, I'll obviously inform, Jennifer, because that would, impact if there's gonna be any bequest at all to the city. So
All right, well, so stay in touch with Jen on anything.
they could always drag negotiations out after December 23rd. I can close out the estate. And now they could still sue in Superior Court. So.
Yeah, well, if they notify you within the 6 months, then they got another
6 months.
18 months to file the lawsuit.
18 months to file. Yeah, you're right.
And, but, you'll know by December 23rd whether it's gonna happen.
Yeah, I've been told they're probably not going to do that. But I wasn't given 100% assurances, but I was given reasonable assurances by somebody I trust. But obviously things can change if negotiations with the city break down.
All right, well, we appreciate you coming in.
All right, thanks for having me in.
I have one follow-up question.
Absolutely.
Did I hear you correctly that the landlord hired someone who specializes in knowing the value to look when they cleaned out the?
That is hearsay from other individuals. I have not spoken directly to the landlord's representative as to who they hired. I know that they did have somebody on. I live relatively close to there, so I've driven by at times, and they had someone cleaning it out. I don't know if it's completely cleaned out. It's pretty well gated now, as I recall, so you can't really see in as well as you could before. But that's what I've just been told by someone that I trust, but I don't have any direct knowledge of that.
And just to kind of follow up, so you said that Walter abandoned, or the property on the Lafayette Road address was abandoned. Is that a formal acknowledgement, or just the landlord declared you've abandoned because you don't remove it within a certain period of time?
He didn't legally abandon his property. By order of the court, after the eviction notice was served on him on the day that he passed away, or I'm sorry, the writ of execution, writ of possession was served on the property, that day. There's a brief period of time. It's kind of a little bit of a gray area for commercial units. Some judges would interpret that on that day, the property is legally abandoned because the landlord has a right to re-enter the premises. There's different rules for residential tenancies. But at some point in time, whether it be 30 days or 45 days, that property became legally abandoned through an order of the Superior Court, as well as not specifically ordered in the eviction notice, but I don't even know if there's an RSA on it, but I'm relatively sure the landlord requested a specific date which had expired, before the estate administration was filed, and before we would have had an opportunity to say stop, freeze. And the other problem is we never had access to we never had legal access to the property. I mean, the property was condemned, so there was no. The landlord was eventually allowed to go in, it appears, but
Condemned by the city.
yeah, we were never allowed to go in and start moving out books from the day of the condemnation in 2024 through Walter's passing. We were legally prevented. It says right on you could be charged with a misdemeanor if you went into the property. So there was no right of access at that point anyway, even though he still continued his tenancy throughout that period of time. There was no legal right of access to the building to remove anything.
Okay.
All right, thank you.
Thank you for coming.
Appreciate you coming
Thank
in.
you, guys.
Thank you.
Thank you.
Thank you.
How's your dad's golf game?
As it always has been. It's as bad as it's always been. I'm playing with him tomorrow, though.
Oh, tell him I said hi.
I will. Thank you. Thank you, guys.
Okay. All right, we're almost done here. So next item is the modification of our rates, our management fee with TD. And thanks to the persistence of Commissioner or Trustee Weeks, we do have an answer, and TD has agreed to reduce its advisory and management fee from 20 basis points to 17.5 basis points. And so, and you've seen the materials that they sent us. There's kind of two steps to this process. The first is whether we are in agreement with their proposal. And then secondly, whether we're prepared to accept the documentation that they have submitted. And the reason I say that is because it's, instead of a one page, we're changing the fee. It's,
Well,
you know.
I think my request would be, before we make a decision whether we accept the new fee, is request that Jen review the old document with the new document and inform the trustees of any changes that may affect us.
In fact, that's exactly what she's doing right now.
All right.
So,
But send it to all the trustees.
Okay.
yeah, or come back in and report it to us, whichever. Yeah, so the good news is that it's a reduction, which is, I believe, one of the lowest that I've heard, certainly in the municipal trustees. And it's, I guess it's effective whenever we're prepared to get back to them and say, yes.
Yeah.
So, and as you said, as soon as these materials came in, I shot them over to Jen, asked her to do exactly what you're doing, which is, you know, familiarize herself with 2021 documents and then see what type.
Make sure there aren't any loopholes that are
I mean,
going to affect us.
right. And any idea when you might get to that on your empty slate?
You know, I don't wanna, when is the next meeting? Are you guys meeting in August?
Yeah, we're meeting the 19th, I think.
Sounds about right.
I certainly by then, but in advance to at least give you some preliminary thoughts.
Okay.
If you put that on the agenda, Judy, for the
Just noted it, yep.
August, and because we would do TD a response.
Yes.
And Judy, would you reach out to John DeQuattro and just let him know that we're having the documents examined?
I will, and are we asking them to come in to do their second quarter presentation next month?
Yes.
Okay, I'll do both at the same time.
Is this reduction retroactive to June 29, or is it whenever we vote on it?
I think that
I think
ends up
it's-
being an open question because, you know, he provided this in late June with the idea, if we were good with it, he thought we could just sign it and get it back to him. We're not ready to do that at this point. I don't,
We could just, once we're assured there are no loopholes,
yeah, I think
we can just say to them, we expect this to be retroactive to July 1st.
Did you get that, what,
Oh, they do it monthly,
okay, and.
right, Judy?
What's that?
They charge us their fee.
Quarterly.
quarterly, yeah, quarterly.
And did you get this assurance in writing of
What-
the rate reduction?
Well, it's in
I do, I have an
these
email.
documents.
Oh, good, perfect, it's in email.
Yeah, there's an email
Yes.
that accompanied them as
Oh,
well.
perfect, thank you.
And they're in each of the modification documents. All right, so I would propose that somebody move to table this until we hear back.
So move,
Second.
and be on our August agenda.
Yeah.
With a report back from Jen prior to the meeting.
Okay, I'll call the question. All in favor indicate by saying aye.
Aye.
And the chair votes aye. Okay. You received all the minutes and materials, not minutes, financial reports and materials. Although I didn't see
I did not receive a dashboard. I reached out to Suzanne, I haven't heard back, so I can forward it after the fact, but it will be the same amount as on the first page of,
and so for you to do your reports, you took it off the bank statement?
I took it off of my monthly report that I get from them, from TD Wealth Management. I get a big packet, so. Yeah, so that, those amounts are, yeah.
Did anybody have any questions with respect to the, any of the reports we received? That's Christmas.
It is.
That sounds like a park ring to me, but. Hearing none, then we'll move on to the final action item, which is another public art trust question or issue, and that is that, as you may recall, when the city amended its public art ordinance back in 2024, it made a change in the retention of funds associated with the 1% for art that was set up on any major city infrastructure project, and the ordinance provides that at least 75% of each appropriation has to be for art on the premises of the construction project unless there's a vote of the city council to override that. And the new function, the new feature, which is part of the restated ordinance, provides that once the piece of art that is constructed on the premises has been completed and fully paid, that the remaining funds are not held for that piece of art. They're transferred into a general maintenance account that's unconnected to a particular piece of art that would be used for all maintenance of all art within the city and quote other public art purposes. So on the Pierce Island wastewater treatment plant, that art created by Mr. DeBerry has been completed. It was completed last year, been fully paid for. And so Park, including its chair, who is with us today, has certified to us that the project is complete and that the has been fully paid for, and the balance, which is about $10,114 or whatever it actually turns out to be once the interest is updated,
Correct.
is now ripe to be transferred to the general art maintenance account. That's my summary of where we're at. So, first of all, questions about that process or procedure? Okay. So,
my only question, maybe Chris can answer this. In the future, is there going to be a lot of maintenance that's going to be needed?
on what?
The idea of the ordinance was that maintenance wouldn't necessarily be for that specific piece,
Right.
but would go into a general account. And for example, Public Works has asked us to contribute money to shoring up My Mother the Wind, which is the whole area there is eroding underneath it, and it was only fixed 4 years ago and it's eroding again. So that would be an example where that's owned by the city, has nothing to do with, you know, any of the funds that we use for that, but funding could be contributed toward that.
How about the burial ground?
We contributed some to that, and we had, there were funds remaining in the burial ground trust that contributed to the most recent refurbishment of everything. But I can tell you that there will, in the near future, there will be a need for some of the other stones that are there to be replaced. So, that's another example.
And that would, this maintenance fund could help to cover that.
Good. And that's how we're also using our CIP funds.
We actually still have a burying ground trust, which holds
A little?
30-something,
30,000.
30.
Oh, yeah.
So,
So that's good.
yeah, until that's used up for
Right.
that maintenance on that site, then that project would fall under general.
Informally, as a policy, not an official council policy, but just an operating committee policy, we have, we want to keep a balance of 25,000 for maintenance things that come up. Because as you probably know, Public Works doesn't do anything for free anymore. It all has to be raised and paid for. So that's why we're really trying to squirrel away maintenance funds.
Yeah. And rightfully so, because,
Yeah,
otherwise, we let things fall apart.
exactly, yeah. And we see this as, most of the art in the city is privately put up, but we see this as going for any of the city-owned pieces. And of course, there was never any, Peter, to your point, there was never anything set aside for some of those earlier pieces. And
Yeah.
pieces like the Cabot Lyford pieces, which are incredibly valuable, don't even have signage. And so, we use some of the funds for things like that as well.
Well, we had a request recently on the J. Smith Park.
Right, which has its own.
Yeah.
Yeah.
So,
You'll see that again soon.
Huh? It's something that if we don't maintain it, everything's gonna fall apart.
Right. Some of it has a life, like, murals have a life, but, many of these other things are gonna be there for a long time.
The cost of fixing the Civil War Memorial, Goodwin Park.
Exactly.
Okay, so,
I moved to authorize the transfer to the maintenance fund.
okay. It's technically gonna be a recharacterization from one fund to another, because it's gonna continue to be, it's all part of one of the big CDs at Newburyport Savings Bank. So this is sort of an internal accounting as opposed to that. And just to be clear, Chris, we keep the CIP monies as a separate accounting as well.
Sure, because it's public money.
Yeah, well, and this money is public money as well.
This money is public money, right?
So if it's, just to be clear, it's not for purposes of this conversation this morning, but if it's you're contemplating that at some point some of that CIP money will become part of the general, then we would need to have a separate
Okay,
decision on that. But we're gonna, for time being, subject to this vote, we will have the 10,000 plus put into general maintenance and can be used for things like the $3,000 that you're drawing off of CIP now, take care of the mortal, the sea and the mortal, the
cut.
cod in the mortal sea. But you could come back and ask for that similar type of thing off of this general account in the future.
Sure.
Oh, I have a question.
Yep.
Is there any distinction between indoor and outdoor art? Is this strictly for outdoor, or it doesn't matter, or?
Chris could probably answer this better, but there is no distinction from our perspective.
Okay.
Indoor, outdoor, as long as, it's public art. And I think the difference may be that the ordinance suggests that if somebody is donating a piece of art for placement on a city property, that the art should be accompanied by some type of endowment to cover its maintenance going forward. That would not typically be the case with an indoor piece because it's not gonna require the same level of maintenance. Okay, so Peter made the motion for the recharacterization. Do I hear a second? And I'll call the question. All in favor, indicate by saying aye.
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 And the chair votes aye. Okay, so that's it for, do you have more checks for us to sign, Judy?
I have a lot of checks,
The scholarship?
scholarships.
Okay, we'll
but-
get to that.
But we can do it after the meeting if you
Yeah,
want,
we'll wrap that up.
Okay.
So then we got public comment. Would you like to add anything else?
No, I just wanted to be here to answer any of the questions.
And I just, you're clear, the procedure we kind of went through of after you certified to us that the project and a set for our one is done and the balance can be transferred, that works for,
Yeah, it's really a council issue, you know. I mean, we give a memo to the council that is a recommendation and that really details a fair amount, and it's then really up to them as to how they frame their motions.
well, but this is a separate function, so the council decides on, you know,
Right, but I mean,
accept
a
your
disbursement.
recommendation, hire, enter into a contract, have it installed, authorizes us to pay it. After that project is done, the remaining funds just get recharacterized, and so from our perspective, we just need a certification from you.
Right.
And that doesn't require the city council to vote to declare the,
No, it doesn't, but it does go to the city manager.
yeah, no, yeah.
Yeah.
It always comes from the
Yeah.
city manager, but,
Yeah.
okay. All right, so no other public comment, and that being the case, I will entertain a motion to adjourn.
So move.
Second.
All in favor?
Aye.
Aye, and aye.